I need it. You have a sign. Stop by and get your phone.
Good morning, Ms. Sanders.
Good morning, Judge McBurney. How are you?
I'm well. It's been a minute. How are you?
I'm fine, thank you.
You look like you're in some strange court reporting cave with striped
Yes.
walls.
Yes, my happy place.
Your happy place. Well, good. I'm glad to hear court reporting makes you happy. Are you ready to cover? We've got a calendar this morning with potentially three bond hearings, and then we've got some stuff at 1. Are you with us for both calendars?
I'm with you all day.
Fantastic. Great. Well, why don't we get started? We're going to do Mr. Williams's bond hearing in just a second, but I want to hear from Mr. Adams. I know you're on the call, Mr. Adams, and we don't have Mr. O'Neill here today. He was at Grady for leg surgery, and Ms. Nelson from my staff confirmed just 15 minutes ago that Mr. O'Neill remains there. So he's not here. I don't know if you got a waiver of his presence or how you want to manage that.
Well, I'm frustrated now because I spent an hour last night with the jail people. I met with Mr. O'Neill. They still show him in the system at Grady, but he's not. He's at 5 North in Fulton County.
So you actually were with Mr. O'Neill last night, not at Grady, but over at the county jail.
That's correct, John.
Okay, well, why don't I have Ms. Nelson reach out to the jail, and if they can confirm that Mr. O'Neill is here, maybe they could get him here this afternoon if your schedule allows. I've got another calendar this afternoon, and we could see if we can get him here. I'm also open, consistent. Ms. Nelson's reaching out right now to the jail. I'm also open as soon as we can get hands-on Mr. O'Neill virtually or in person. I'm sorry? You suddenly went silent if you're talking, Mr. Adams. I can't hear you anymore.
Yeah, that worked.
Oh, well, tell me what would work.
If we can virtual him at the jail, that'd be good.
Okay.
Well, I can wait for appearance, whichever was best for you.
Why don't we do this? We're going to go in the order on the calendar. So we'll do Mr. Williams first. While we're doing that, Ms. Nelson will reach out to the jail, and if they confirm that he is on 5 North, which is what you said, then they kind of owe us one, and maybe they could get him into a booth and we could patch that booth in here. If that's not going to work out, and you are willing to waive his appearance, then we can certainly still talk about bond. We're not going to be talking about things that it's certainly waivable if you're comfortable doing that.
Okay, yeah.
All right, well, let's see what happens. But let's start with Mr. Williams. Then we'll do Mr. O'Neill in some format. And then we've got Mr. Stokes on the calendar as well. So if we could bring out Mr. Williams, please.
Yeah. Your Honor, if we may take a brief pause, I will reach out to ADA Abadi to see his current location.
Oh, okay. Neither of you was planning on handling the Williams matter.
No, Your Honor.
Okay, well, sort of par for the course for poor Mr. Williams and Mr. Tolbert.
But he's got an unindicted case. He has an unindicted case, so that is going to throw a wrench in things. Thank you.
I think it's going to be just another couple minutes on you. Do you want him to go ahead?
We're going to figure out where Mr. Abate is. If he's 2 minutes away, then we'll keep Mr. Williams right there.
morning, Your Honor.
Good morning. How are you?
Great, great. May I please get Mr. Williams and Mr. O'Neill's name and case number?
Sure. Did you not get the calendar? I think this may not have gone out to everyone. So Mr. Williams is Ramelle, Ramelle, and his indictment is 19 SC 167684.
Okay.
Mr. O'Neill is Anthony O'Neill, and I've got O'Neill as O''Neal.
Okay.
And his indictment is 19 SC 172809.
Thank you.
You're welcome. What do we hear from Mr. Abate?
Nothing yet, Your Honor.
Radio silence.
Radio silence so far, Your Honor. But I did send him a text message.
Okay, well, I apologize, deputies. We're gonna have to switch it around. Let's bring Mr. Stokes out.
Judge, I apologize. I put a note on the Outlook that Adam asked that we hold for his report till 11:30. He was with another victim.
Okay, well, we'll make sure we do Mr. Williams, but we do need the lawyer here. So we're gonna jump over to Stokes while we do a little research on O'Neill. Ms. Jackson, do you need Mr. Stokes's information?
That's all right. You're good.
Okay.
Okay, well, let's get on the record in position 3. This is case 23 SC 186018. It's State versus Stokes. Mr. Stokes is here in court with his lawyer, Ms. Wood, and the state is represented by Ms. Willingham. Mr. Stokes, we're going to talk today just about bond. Ms. Wood has filed a motion seeking to get either bond set or bond reduced. If you've got no bond, she's going to tell me what number she thinks is a reasonable number. And if you do have a bond, it's apparently too high a bond, and she's going to talk about lowering it. I'm going to hear from the prosecutor as well, and then I'll let you know what I'm going to do. When you're ready, Ms. Wood.
Thank you, Judge. Judge, Mr. Stokes is 19 years old. He is a lifelong resident of Atlanta. He has several family members here. I've talked to his father, his stepmother, an uncle, and I've been given numbers of several others. And so he's not a flight risk. He also, one of the main reasons that we're asking the court to set a bond is because I've been contacted numerous times by the complaining witness. They share a child together. She is not scared of him.
This is Ms. Grant?
Ms. Grant.
Okay.
Yes, Judge. I'm not scared of him. She tells me this is all just a big misunderstanding. She needs him out to help provide for the child. He has no bond set on this case. I would note for the court, the jail booking screen is incorrect. There's an unindicted case that shows he's in no bond status on that. But in the case manager side of Odyssey, it looks like he does have a bond. So
What is that CP number?
it's 21 CP 201486. That's an entering auto case.
Okay.
We are asking the court to consider setting a $15,000 bond on this case. Again, he's 19, he's an Atlanta resident, he has one child, he has family ties here, he has a 10th grade education from South Atlanta High School, and he worked previously with a construction company called High Rise Remodeling. So we would ask that you consider setting a $15,000 bond on this case.
So his one child is a child he has with Ms. Grant.
Yes, Judge.
And what Ms. Grant tells you is, I don't know if it's so much I want him out as I need him out. It could be both, but at a minimum, it's I need Mr. Stokes out for his earning power. And maybe it's just his parenting presence to help with the child. How old is the child?
It's a baby under 1. Judge.
Okay.
2 months. Okay.
It is an infant. All right. Let me find out from Ms. Jackson first a little bit about Mr. Stokes's criminal history, and then we can hear from Ms. Willingham.
Your Honor, I apologize to the courts, but we're not prepared to give the history right now. I'm going to have to run all 3 of those records.
Got
They're
it.
Not in our system.
Okay. Do you need any more information about Mr. Stokes, a date of birth or anything, or you've got what you need?
I'm looking it up now, Your Honor. Thank you.
Okay, great. Take your time. Sorry, we didn't get that to you.
That's okay.
Ms. Willingham,
Judge,
is your microphone on?
it is, I was gonna go ahead and spell my name. I know the court reporter asked earlier. It's Jazmin, last name Willingham, Willingham. Your Honor, number one, I can also speak a little bit to his criminal history.
Great.
As to the defendant's criminal history, it looks like he has he has a possession of a pistol or revolver that was in 2021, of January of 2021. It does not appear that case was disposed of, so it's still pending. Then he has the 21 CP 201-486, and then we have this charge.
And you agree the one ending in 486, that's an entering auto?
Correct, Your Honor.
Okay.
And Your Honor, as to the victim in this case, our office has made multiple attempts to get in touch with her. We know that we have the correct information. We have not received calls back, so I cannot state that she desires for the defendant to come home, but my concern would be that the child that he referenced, she was pregnant with at the time of this incident. On June 6th of 2022, officers responded to 1041 Irish Street Southwest in reference to a dispute. When they arrived, they spoke with the victim, Zariah Grant. Ms. Grant advised her boyfriend, Demazi Stokes, got upset because he went through her phone and saw text messages from other men. She advised that the only people inside the house in the same room was her and her baby sister. She further stated that Mr. Stokes became aggressive and got on top of her with 2 hands, strangling her throat for about 5 seconds, during which time it became difficult for her to breathe. She advised Mr. Stokes then bit her on her right shoulder, which left a visible mark, which was captured on body cam. When Mr. Stokes got off of Ms. Grant, he then damaged one of her iPhones, but Miss Grant was then able to escape with her baby sister and ran across the street where her sister, Zanoa Grant, was located. Before she could get there, Mr. Stokes stopped her in the middle of the road. He then damaged Miss Grant's second phone and threw her purse, crushing everything inside. Mr. Stokes then went back into the incident location and grabbed a knife and began damaging Miss Grant's bed. He then walked back outside where he kicked the glass door at 1044 Irish Street, where Miss Grant was located at that time. So, Your Honor, our concerns would be whether or not he actually would still be a threat to the victim. I do understand that they have a child together, so I understand that there will be some communication, but she was pregnant at the time of this incident, so I would just be concerned about that contact.
Got it.
I would concede that he does not have an extensive criminal history.
Sure. Sounds like he has a unindicted matter, and we don't know exactly what flowed from what sounds like a misdemeanor arrest in 2021. Ms. Wood, where you mentioned that Mr. Stokes has family support,
Yes.
where would he stay?
So I've been texting back and forth to confirm. The notes from my predecessor have that the 898 Washington Street Southwest, Atlanta, Georgia, 30315 is still a good address. That's, I believe, where his grandmother lives, but I was trying to confirm that for myself. I haven't gotten a response back just yet.
It's my godmother.
That's where she is.
It's my godmother.
Oh, your godmother.
Yeah.
What's her name?
You want to run?
Okay.
Bert.
Mhm.
And my grandma.
Thank you.
Well, we just need to settle on one, because if Mr. Stokes is released, he'll be subject to pretrial supervision, and they'll obviously need to know where it is that he's staying.
Judge, he tells me that the 898 Washington Street Southwest address is still valid and that's good to go.
All right, and that's godmother, grandmother?
Godmother.
Godmother.
Yeah, Judge. My
All
apologies.
right.
Your Honor, if you would like, I can give you Mr. Stokes' history now.
Yes, please. Thank you for jumping on that one.
The defendant has 3 cycles. The defendant's last arrest was July the 17th, 2021, with the City of Atlanta Police Department for entering an automobile with the intent to commit theft and a misdemeanor obstruction of an officer. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
Thank you, ma'am. Okay, so Mr. Stokes, I am inclined to set a bond, but I'm also very interested in having Ms. Grant speak with Ms. Willingham or someone from the district attorney's office. That's not your job or your problem, because really you should not be having contact with Ms. Grant yet. Ms. Wood, what I'm going to do is ask you, it sounds like you are able to communicate with Ms. Grant, and you might be able to help her appreciate the importance of at least a brief conversation with Ms. Willingham or a victim advocate, so that Ms. Grant can relay to the state side of the equation her sentiments. That doesn't dictate what Ms. Willingham's going to do. This is an indictment and she's free to pursue it to the fullest extent. But I'll be more comfortable if Ms. Grant is saying that as well to the state, assuming that is what she says. And so what I'd like to do is describe the parameters of a bond now that I'd set, and Ms. Nelson can even draft it, but I'm not going to sign it for a little bit. I'm going to give Ms. Grant a window of time to talk with the state. I'll probably still set a bond. It just might be a higher bond if we don't get input from Ms. Grant through the state, and it might be more restrictive than Ms. Grant might want it to be based on what she's been telling you. So the children who are named in the child who is named in the indictment, AT, that would be Ms. Grant's little sister. There's count 6 is cruelty to children in a 3rd degree. And that basically when all this happened, Mr. Stokes allegedly did these things knowing that AT was present. That's not his kid. His kid wasn't born yet. So I'm just curious, you had mentioned, I guess it was Ms. Willingham had said, hey, it was in the presence of Ms. Grant's little sister.
Yes, Your Honor, the AT is her little sister.
Okay, I don't know, I was asking Ms. Wood. Okay, thank you. All right. So what I will do is set a $20,000 bond, and I'll divide it across the counts if I need to. It may just make it a flat 20, assuming Ms. Grant contacts the state and expresses similar sentiments to the state. If we go by a week or so and there's no update from Ms. Willingham, then I'm going to set a $30,000 bond. This will be subject to pretrial supervision. Ms. Jackson, can someone on pretrial supervision be required to go to anger management, for example? Can I put a condition of bond like that, and pretrial can not provide the anger management, but ensure that their supervisee enrolls in a class and takes the class?
Yes, Your Honor. Just has to be in the bond order, please.
Great. Okay. It'll be in the bond order. It will be a condition of your bond, Mr. Stokes, that you take an anger management course. No violent contact with Ms. Grant. If Ms. Grant talks with the state and says, I need Mr. Stokes to be around our child. If we don't get any input from Ms. Grant, I say we, if I don't get anything from the state, from Ms. Grant, then there'll be no contact with Ms. Grant. And you will be required to reside at 898 Washington Street with your godmother. That doesn't mean you have to be there 24/7, but if pretrial services is looking for you and it's nighttime, that ought to be where you are because that is your home. And if you need to move, want to move, it's okay as long as pretrial services approves of your new address. But you don't willy-nilly say, hey, I'm going to sleep over here this week. I'm going to be over here this other week. We need to be able to make sure that you are where you said you're going to be. Ms. Willingham, I know you're operating a little bit in the dark with no contact from Ms. Grant. Any other conditions?
Your Honor, at the moment, no. However, in the event I ask for anything additional, I will obviously include that, but I can't imagine, I think you've covered pretty much everything that we typically would.
Okay. If your conversation with Ms. Grant, should you have one, yields any other recommended conditions, just put it in the email that you'll be sending to me and Ms. Wood and Ms. Nelson saying, hey, we spoke. I actually think it needs to be the case that Mr. Stokes doesn't come to her place. No violent contact, stay away from her residence. I'm making that up, but that may be a boundary that she wants drawn, and that would be a condition of the bond. Okay. And this will be through the sheriff's 10% program. Ms. Wood, anything else on behalf of Mr. Stokes?
No, Your Honor, just that I just texted Miss Grant, and so she's going to reach out to Miss Willingham today.
Great. Okay. Again, I won't wait forever. If we get into next week and I haven't heard from Ms. Willingham about contact with Ms. Grant, I will set a bond. It'll just be at that higher amount, which presumably will be more difficult to make. And the conditions may be a little more restrictive. Mr. Stokes, do you have any questions?
No, sir.
Okay. Were you living at your godmother's house when this happened?
Yes, I was, but I was at her house. I had spent night at her house that night.
Her house meaning Ms. Grant's house?
Yes.
Okay. And again, it may be your bond is set with conditions where it's okay to spend time with Ms. Grant. I need to hear from the prosecutor what Ms. Grant says to her. And then being around Ms. Grant is okay, but you'll need to make sure from Ms. Wood which of the two bonds it is. Okay.
Mm-hmm.
All right. If there is nothing else, we will move on.
Yeah, I don't know.
Ms. Harp, I signed your somewhat trade. Was that going back to? Okay.
Your Honor, that concludes my business for this morning. May I be excused until this afternoon?
Yes, ma'am. Seeing a lot of you. Mr. Abate is here, so I think we can do Mr. Williams now. Oh, you guys, hey, you guys are facing each other. All right, let's get on the record with position one, State versus Ramel Williams, 19 SC 167684. Mr. Williams is represented by Ms. Feely. Both of them are here in court. Mr. Abate represents the state, and we are here on what I think is entitled motion, well, on the calendar it says motion for reconsideration of bond. It really would be modifying the bond. Mr. Williams does have a bond. I set bond for him in April of last year. So his bond is 1 year and 8 days old. Clearly an amount that Mr. Williams cannot make because he is still in custody after all that time. So we will spend a little time talking about whether I should lower the amount, and if so, why, as well as next steps, because there has been a very positive development concerning Mr. Tolbert. Which is good news for everyone seeking closure in this case. Whatever closure is going to be, it sounds like closure is going to be a trial, and then the 12 people in the jury box will decide what closure is. But certainly it is long past time for that trial to occur. Ms. Feely, why don't you get us started?
Thank you, Your Honor. So this court did set bond in the amount of $300,000 back on April 5th of last year. Mr. Williams has been in jail since February 13th of 2019, which is 4 years, 2 months. As far as the case goes, I think the court is relatively familiar. It is a murder case where a man was shot in the leg, but subsequently did die from those injuries. There is a co-defendant in this case. This is potentially a very tribal case in terms of how I have spoken with Mr. Williams about this.
When you say very triable, meaning they're great defenses, or you're ready to go, and of course you've been ready, or maybe both? Okay.
The witness statement originally was that the co-defendant was the one who was the shooter after an altercation. So there's plenty to work with there, as well as the physical evidence really more points to Mr. Tolbert. I think the issue that we're running into is the state, I believe, intended to try them together. And so I talked with Mr. Williams a lot about potentially moving to sever him to speed things up, but I don't know that that would have done that anyway, because I think Mr. Tolbert would have needed an attorney to counsel him about his involvement in Mr. Williams's trial.
Right. I know Mr. Tolbert gave a statement because one of Mr. Tolbert's many conflict defenders filed a motion to suppress it, but then said he wanted to wait on me ruling because he wanted to talk to Mr. Tolbert about it. This person's now a prosecutor, so they better not be talking about Mr. Tolbert's statement. And then we languished for months because the replacement for that conflict defender was trying to get up to speed and then was diverted to another matter. But Mr. Tolbert now has a lawyer who I am confident will be ready in short order, whatever ready means. It could be that there's a joint motion for severance. I don't know. And we'll hear a little bit from Mr. Abate in a moment about severance or not severance. I'm pretty sure we navigated Bruton, no Bruton, and the state's view was if we need to not use some part of Mr. Tolbert's statement to try the two together, then we won't use it. But that's not my decision to make, and I don't mean to put those words in the state's mouth. That's my dim recollection.
Certainly, and that went into the strategy call of whether to move to sever to start with. But in any event, he has been in jail a long time, as the court is aware. He's 33 years old. He's originally from Chicago, but he's lived in Atlanta for several years. Court might have noticed he has several family members on Zoom this morning.
I see that we've got a sister and a mother and a brother at least. There are a few unlabeled call-ins, but Mr. Williams has always had family support.
Yeah, he very much does. He also has a young daughter who was born after his arrest. Her name is Alicia. That's always heavy on his mind when I speak with him at the jail. He would remain local, and I don't have the address written down, but I believe his sister could put that in the chat if it needs to be somewhere where the court can include it in an order. But he would remain local. The original bond order required an ankle monitor, which of course would keep him where he needs to be while he's out. course, he's been in jail for a long time, but he was gainfully employed when he was out. He was a forklift operator. And although he has been in custody this whole time, he is in the honor dorm. He doesn't have cause issues.
I noticed the change in color of outfit.
So he has all the extra privileges as well as extra responsibility that comes with that. So he is trying to make the best of his situation. And that is one thing about Mr. Williams. He's been, despite his long, extensive pretrial incarceration, has been more than cooperative, very easy to establish a rapport with for me. I've just been really impressed with his ability to remain positive through this kind of long, drawn out situation that he's been in. But it hasn't been to no detriment of his. He has been having a very difficult time being away from his family and being away from his life. So we are asking the court to consider a significant reduction, given that he has not been able to post this bond. The original bond order was $30,000 per count. We're asking the court to consider $5,000 per count for a total amount of $50,000, which would still be a stretch for his family, but would certainly encourage him to appear in court when required. So that's our request this morning.
Okay. Where does Alicia stay with Alicia's mother? And is that in the Atlanta area?
Okay, yeah, I just wanted to verify. I thought that's
Okay. I wasn't sure if it's Chicago or here. I didn't know. Okay. All right. Mr. Abate, I know the state opposed bond to begin with. The state has also acknowledged throughout how this has dragged on, which I think is about 90% attributable, and I shouldn't put numbers on it because I don't have all that data in front of me, of getting representation consistent and of, I guess, persistent representation for Mr. Tolbert. I think we've finally solved that, but the state has been ready, I believe, from long ago.
That is correct, Judge. On all accounts of the court's recitation, state is ready. We did oppose bond previously on the, at least when he was granted bond on April 5th of 2022. I know he had previous bond hearings prior to that one as well, where we also held the same position. I would just bring to the court's attention, I know Your Honor takes pretty good notes, but he is a 4-time convicted felon, some involving drugs and others involving offenses that involve violence, like aggravated battery on a government official. He also, in 2016, was convicted of possession of a firearm by a convicted felon where he served 6 years. All of those are out of Chicago. He had a fairly extensive juvenile history where he had 2 burglaries, a robbery, and then an arson juvenile adjudication, Your Honor. So the state would contend and submit to the court, as we did last time, that we believe he is a significant risk of committing felonies pending trial, which is why the state would oppose his bond being reduced. I would also bring to the court's attention, since being in custody, he has had several instances where he was disciplined. They were in 2019 and 2020. He hasn't had one since October 13th of 2020, but he had possession of a contraband substance, marijuana, in 2019. He was cited for fighting assault or battery in September of 2020. And then in October of 2020, he was also cited with the jail disciplinary system for arson and possession of a weapon and chemical agent, contributing to an unsafe environment where he was lighting fires and things of that nature in his cell. So that's the history based on his stay in custody. It seems like Your Honor noticed his color of his jumpsuit has changed. So in all candor, it seems as if his behavior has improved, which is great. But the state would respectfully request that the motion for reconsideration, or I guess a modification of Your Honor's prior bond, be denied. The victim's family lives out of state. They are present. I don't have any indication they would like to make a statement other than the one they made last time, where they believe that Mr. Williams should remain in custody as we wait for trial.
I need a reminder on the scope of discovery in this case. Mr. Francis will need to get discovery ASAP, and then he'll need to digest it. And I just can't remember if this is one where there are 9 phones that got dumped, so it's 3 terabytes of data. I know you will guide Mr. Francis towards what you think are the germane parts of any digital evidence like that. But I'm going to be reaching out to Mr. Francis and copying Ms. Feely and you, Mr. Abate, to get his sense for how quickly he could be ready on this. And part of that is determined by, 1, how quickly he gets discovery. I know you'll make it available, but then 2, how quickly he can get through discovery.
So I wouldn't qualify it as one that's a 2 terabyte type situation. The discovery is, I would say it's moderate for, a homicide case. It does involve cell phone analysis, mapping, that type of stuff. But as it's not like Mr. Goolsby's case where there were, hundreds and thousands of pages of cell phone extraction data. So it's not nearly as complicated as that.
Okay. What is your current thinking about severance? Am I remembering it correctly that the state is not seeking it? And insofar as Mr. Tolbert's statement would generate Bruton issues, you wouldn't use it, or there aren't Bruton issues with it? I never ended up listening to it because Mr. Cladis had, we started to litigate it. And then he said, I need to go talk to my client. And then he said, now I'm working for Mr. Abate. So we didn't go any further.
So there are, there is Bruton issues for sure. At this time, we had the motion, or we gave Your Honor the disc to listen to make sure that Your Honor made a ruling that it was, knowing and voluntarily, his statement was knowing and voluntarily made, and he waived his rights. At this time, I have no intention on severing and having to use the statement against Mr. Tolbert at the time. My preference is to try both defendants together. That's my strategy at this moment.
Okay. And that's not a change. I just asked because if something shifts and they need to be severed, then we can try Mr. Williams right away. Otherwise, I need to wait, not for very long, I suspect, for Mr. Francis to be in a position to say, I can do this. And that's the input I need to get from him. Okay. Ms. Feely, anything you want to add in light of Mr. Abate's comments? And you don't need to talk about the jail stuff. I think in the end, he's acknowledging, Mr. Abate is, that may not have been so great for Mr. Williams in custody to begin with, but look where he is now. And that's what I'd be more focused on. If it was the reverse, you'd have a more difficult argument to make.
Yes, Your Honor. Just given that we have good contact for his family as well, I don't see any reason that he would have issues being in court when required to do so. So we just would urge the court to consider reducing the bond, and while we continue to hopefully have a trial this year at some point.
It'll be this year. I'm not, given the assignment that we got out of our C3 project, I'm heartened. I don't get to pick who we get, and I batted 500 on this last round. But we should be good. So what I'm going to do, Mr. Williams, is what I said, which is reach out to the newly appointed lawyer for Mr. Tolbert to understand how much time he needs to get ready. And based on the time horizon he paints, and there are really 2 issues. I didn't touch on the second one. One is, how much time does he need to get to know Mr. Tolbert and get to know the case? The other is, what is his schedule like? He is stretched thinly because he has stepped in lots of these scenarios where there is a defendant who is entitled to a lawyer, and our system has failed that person, like Mr. Tolbert. And you are a collateral damage of that. You've been ready to go through at least this lawyer. I'm glad you two are getting along. Ms. Feely, if you look a little deeper in the docket, you'll see that Mr. Williams and his lawyers haven't always had as productive a relationship as the 2 of you have, as I want to keep this one. But Mr. Francis, that's the lawyer for Mr. Tolbert, is, I am sure, wanted in lots of courtrooms. And so if he says I can be ready in fairly short order, I will specially set this to protect him. This is an old enough case that he won't have many that are older, I hope. It's just that depressingly, there are others that are older. And we would jump in front of any other conflict he might have for that calendar. The other option we have is to put it on our consolidated trial calendar, and it's old enough that it would be at the top, having seen what else is out there. And I'll do whatever is sooner, and I frankly may do both, especially set it here. And if we can get it onto a consolidated calendar before then, again, consistent with Mr. Francis being ready, then we'll take the first available date, because that's what this needs. So what I'm going to do, Mr. Williams, is see what Mr. Francis says. And if his time horizon is not what I was hoping, and he says, you know what, this really isn't until 2024 that I can be ready, then I will reduce your bond. I don't know by how much. It's going to depend on how far out Mr. Francis's availability is. But if he says to me, I can be ready in 2 months, and I see a calendar I can put this case on in 2 months, I don't think it's productive to change things. We'll have everyone we need to try the case if we maintain the status quo being with Dennis Francis in as Mr. Tolbert's lawyer. So I need that piece of information, and then I'll enter an order. I won't keep anyone guessing, but I'll need to hear from Mr. Francis. He filed his, oops, this is Mr. Williams. His entry a week ago. So he's fresh, and you may not even have known that he made it to the case, Mr. Abate. Can your support team start rounding up discovery?
Yes, Judge.
Great. I'll put that in the email to Mr. Francis. Ms. Feely, anything else on behalf of Mr. Williams? Okay. All right. Thank you all for this.
Thank you, Judge.
I'm ready for you, and then we will shift to Mr. O'Neill. Good morning. How are you? I'm all right. We got anything good?
All right, enjoy your day.
Somewhat, she says.
That's fine. You're totally
Oh,
fine.
yeah.
If there's any specific
Whatever you guys
Flowers,
think.
right?
Or whatever.
Oh, many Agasals.
I don't think he's gonna take 10, but he might.
Well, this is mine.
Because there's one that's definitely.
The re-indictment. So I recognize the names.
Proceeds in the car or something.
I don't see Trump in there. All right.
I think you're right. I'm after that. I'll see if I can find.
Thank you. Take care.
And I think they're in the same car. His girlfriend's car.
Yeah, same
I
car,
don't,
same.
I think it's just me and these random private
I'm ready to try it.
I'll find it.
Okay, I appreciate
Be
it.
well.
Judge, may I be excused?
Yes, sir. Thank you for being here.
Thank you.
petition for writ of cert.
Don't sign for the clerk?
Yeah.
Okay. You know, we're only doing writ of certs for a few more months, and then we're done with this awful process.
Yes, absolutely. July.
July 1, it's going to be a beautiful, very welcome change.
I'm looking forward to it because I think I have probably 3 or 4 more before July, so.
It's just such a antiquated, cumbersome process. But the, I don't remember what the new thing is called, notice of appeal, petition for reconsideration. It's just this one form.
Yeah.
All we need.
It's a straight appeal, so.
Yep.
And I think so many people were confused by the process, so some people are doing a straight appeal and.
Right. Well, and then for procedural reasons, they would lose out and not on the merits. And that's what, that's the value of the legislation.
Well, thank you so much.
You're welcome. All right, let me see if they're. All right, the Williamses aren't happy to know. Mr. Adams, we do not have an update from the jail. Ms. Nelson is on the phone with them now, and her response is they are still looking. So we are not going to have Mr. O'Neill for the hearing. If you want to waive his presence, we can have the bond hearing. If you would like him to be present, which I understand, then we will figure out when we can get our hands on him and either make him available virtually or get him brought over. Tell me your preference.
Well, it'd probably be best if he was present.
Okay.
He's been in 3.5 years, so.
He has. I'm sorry, go ahead.
What they need to do is just call 5 North and he's there. So.
Okay, well, and that's what Ms. Nelson's been trying to do through the folks at the jail, but you know what that's like.
Right, understand.
We will figure out once we can track Mr. O'Neill down the soonest possible date, either for virtual or in person. You're welcome to appear virtually. It just we'll grab the first time we can get Mr. O'Neill here. Just some days I have virtual slots, some days I have in-person slots, and we'll make that happen. But while I have both of you here, let's at least talk a little shop about getting ready. This is an old case. I'm pretty familiar with it. The co-defendant has pled. Mr. O'Neill was close to pleading a number of times. I think he had a probation revocation and went into the state system. We've had bond hearings before. I appreciate you trying again with bond. But in the end, we need to get closure on this. Mr. Jordan, are you ready to move forward when we can get Mr. O'Neill onto a trial calendar?
The state is ready, Your Honor, and Attorney Adams and I have been in multiple discussions about this case. I think that we're relatively close. I'm sure ADA Hall doesn't remember the co-defendant, but I do understand the co-defendant sentence was less than the mandatory minimum for armed robbery. So we're Attorney Adams and I are working hard to come to a negotiated resolution here, but we are ready if it needs to be tried.
Got it. It may be also that Mr. Palmer, that's the co-defendant, had a different role in the situation than Mr. O'Neill allegedly did. You'll want to certainly look into that. I think a guidepost is Mr. Palmer's disposition, but you'll want to understand, does that set a high water mark or a low water mark for how this plays out? And obviously, Mr. O'Neill can have a trial if that's what he wants.
Absolutely. Yeah.
Okay, Mr. Adams, we will work with you and your support team to figure out when we can get Mr. O'Neill back in here for the bond hearing. I'm more focused on getting a trial date because I know that will either get us a trial or a plea. So we'll look for that as well. Okay.
Okay. Thank you.
Thanks for your time.
Can you hear me?
Yep, I heard you. Thank you. So that wraps up our bond.
Can you hear me?
Yes, sir.
Oh.
Yep.
Okay. Thank you.
Bye-bye. All right. That wraps up our bond calendar. We will reconvene at 1 o'clock for an inquiry calendar, and then we have a probation hearing on Mr. Ratliff. Ms. Wood, is that you're making a funny face, but
Yes, Judge.
that's your case.
It is.
Okay. And I assume Mr. Hiles will show up for that.
I do expect him.
Okay, great. So this Zoom link is staying open. We just set up one for the day. Ms. Sanders, you should be at ease. Go have a long lunch. Well, I guess it would be a 1 hour and 8-minute lunch. But I'll be back at 1 and we'll pick back up.
All right.
Thank you, everyone. I will mute the podium. Short timer. All right, the audio should be working now. Ms. Sanders, are you able to hear us?
Yes, Your Honor.
Great, welcome back. I'll let you know that this is a kind of funky calendar. I'll let you know when we need to take things down as we're working through it. But if you don't hear me say, let's take this down, you can just listen along with us.
Will do.
Thanks. All right, our first position on this inquiry calendar is State versus Darrell Lowe. We did not transport Mr. Lowe for good reason. And I think this is going to maybe be an update. I see Dr. Subramani. I assume that's why and Dr. Shah, we've got the whole team. I appreciate you all being here. Who's here for the state? Huh. Well, that's not good turnout. Mr. Lowe has a lawyer in name, and that would be Eric Johnson, who is the conflict defender who replaced Mr. Cladis. And of course, Mr. Cladis had to come onto the case because at the, I didn't want to say 11th hour, it's like the 100th hour, the public defender's office determined they had a conflict and couldn't represent Mr. Lowe. What I'd love to do, I mean, this is at least informative to me. I don't know if we're going to get a prosecutor here for it. Hey, are you standing in for Ms. Ocom?
Yes, that will be my case, Judge. Sorry, I'm a little bit slower than I used to be.
All right.
My leg.
Great. So I was just explaining to those who are on for Mr. Lowe's case that he doesn't really have representation now. Eric Johnson is the conflict defender assigned to my courtroom. He also is on YSL. So we can't move Mr. Lowe's case forward right now. And sadly, the years of information that a defense team gathered about Mr. Lowe has been lost in the sense that the public defender conflicted off the case right when we were going to go to trial or do something with it. So you're on it, and we have two doctors who have been working with Mr. Lowe for a long time. I'm going to get an update from them, and then I don't think there's more we can do until there is a lawyer who can stand in for Mr. Lowe. That's sort of where we are. And you may have an update from the state.
Judge, I don't have an update from the state's perspective regarding that. Obviously, as it relates to representation, is there any expectation from the court would have more information regarding possible another conflict defender being appointed to represent him, or is it going to be a likely we are on hold until YSL is completed?
That depends what I hear from the doctors. Okay. I'm reluctant, loathe is too strong a term. I'm reluctant to burn a chip to get a lawyer for Mr. Lowe for the case to not go anywhere, because each judge has very limited opportunities to say, could you get me a new C3 or C2? I'm having to do it more than most judges because not only do I have C3 woes, like all the judges, I have C2 woes because I have Mr. Johnson. It's not his fault, but GPDC has declined to replace him. And decline may be the wrong term. They've been unable to replace him. So I'm missing lawyers on 2 levels. And I get the pushback, oh, but Eric Johnson represents him. Okay, get Eric Johnson in court. I challenge you. And you can't. He isn't someone who is taking his eye off of YSL, and I don't fault him for that. So I would need to raise my hand for a special assignment. And I'm all for it if that would move Mr. Lowe's case forward. But if I would use up my special assignment and there's someone at Rice Street who's been there for 4 years named Anthony Tolbert, and if he got a lawyer, we could do his murder trial, I'm going to do that one instead.
And I'm aware, Judge, and that answers exactly what my question
Okay.
was.
All right. Dr. Shao and Dr. Subramani, thank you for taking time out of your day to join us. Is there any update you all have? Is Mr. Lowe stable? Just that we'd hear what we heard from you before. Is there a change?
Sure. No changes. So Mr. Lowe remains stable as he has been since 2019. I saw him yesterday. We had a conversation about today. He was knowledgeable about what might happen today, doing well psychiatrically, stable on his medications. I do want to say, well, I kind of recognize the sort of logistical challenges involved with the YSL case. I do read the news. We have such a long wait list at the hospital. We have so many people waiting for competency arrest for treatment. They're sitting in jails waiting. And he's been stable for 4 years. We can't hold him indefinitely at the hospital as we wait for the longest jury selection in history or whatever I'm reading about YSL.
Right. No, I hear you, and I don't disagree with any of that. My recollection, and I think Dr. Shao can speak to it because I think it was her email to me that pushed back. I became sufficiently frustrated about the lawyer transition that I said, then let's just get Mr. Lowe back at Rice Street. That way he can meet a new lawyer and we'll see what happens. And Dr. Shao said, whoa, warning, that will cause what I suspect we all believe would cause decompensation, bad outcomes, et cetera. So I guess my question then is, well, first an observation. I agree 100% that you have a long wait list. It's actually a topic of much discussion as we consider here in Fulton to set up a competency docket, much like they have down in Chatham County, so that we can make sure we are paying sufficient attention to defendants who are in the restoration process, or if they've been deemed not restorable, but they are in outpatient treatment, that we are in a timely manner conducting the annual reviews, et cetera, all ways in which we as a court tend to fall down. But courts with competency dockets in Georgia and elsewhere, we actually met with some judges in Colorado as well, who do very well with that. We want to do the same thing. And in doing so, we have learned the terrible backlog you all have. And Mr. Lowe, he's not helping move that backlog. So what is if it's, you can't keep him much longer, where would he go?
So I know you had asked Dr. Shao maybe for an update on what she had said to you. Do you want to do that first, Dr. Shao?
And I remember that, Your Honor, and I remember what I said back then. The problem so far is our ever-growing list, and also, to put it very nicely, safety of our staff is important too, and there's issues. And there is no
with Mr. Lowe or with your facility writ large?
No, with Mr. Lowe's behavior. So I have no problem holding a defendant who needs treatment who is not a threat to our facility to remain.
Right.
But in reconsidering it and not getting during this time, we've not gotten many updates. I understand the lawyers are busy, so I just want to make sure things are moving along. If they can't, what I would propose is for him to be moved back to the jail and with your order to give the same medications from Georgia Regional and work with them.
Okay, I appreciate that. What I think I'll do is draft an order and run it by you and Dr. Subramani to make sure. I won't list medications. That's not my role. although judges apparently now get to decide what medications are safe and what aren't. But I just want to make sure that the language I put in there is adequate, that our jail understands that they'll get basically the treatment regimen that you all have Mr. Lowe on, and whether they copy it one for one or they substitute a generic for what you're using, I won't get in the middle of that. But I'll run that order by the two of you. And if you say that language ought to do the trick of getting the jail to prescribe and administer to Mr. Lowe that which you are doing, I think that's the right next step, because I share your concern about equity for others needing your resources. And then, of course, I hope the state will reach out to you to get whatever reports, and if I need to issue an order authorizing their release, I will, that would document the types of things that cause you to say, Dr. Schauer, that you're concerned about staff safety, because I think that feeds into ways in which this case moves forward. So that's been a very helpful update from both of you. And Dr. Subramani, you may not have been done. We're going to give Dr. Schauer a chance to weigh in. Was there more you wanted to add?
No, I was just going to say, when you had asked what would be where he could go, but Dr. Schauer covered that. So back to Fulton County Jail.
Got it. You weren't going to offer up a facility I had never heard of. It was, it's either your place or mine, basically. All right. Anything else, Dr. Schauer, Dr. Subramani?
Not for me, Your Honor.
All right. I appreciate both of you being on this call. I will draft up an order and run it by you, and make sure that it's got the right language. And then I think that's how we will take a next step with Mr. Lowe. And then my role will be to try to line up counsel for him and work with you. Okay. Thank you so much. All right, Mr. Kane, the answer to your question is Ms. Willingham, who is here in court. She is the prosecutor handling Mr. Pitts's case, as well as Ms. Diaz Ortiz's case. We're almost there. You guys are positions 3 and 4. You're done. All right. Yep. Good luck with your leg.
Thanks.
But we have Tori Harris first. So, Mr. Jordan, Ms. Wood, Mr. Harris is, what is his status right now?
Judge, he's actually here. I had him sent down.
Oh.
I did speak with him though. I thought he was at Georgia Regional. He's still at 3 North. I've been talking with Ms. Patterson.
Maybe he and Mr. Lowe can.
Right.
Wow.
So I've talked to Ms. Patterson and Ms. Primer-Vicker, both helping me try to figure out if we can get an update. I had sent an email to one of the doctors that I had been corresponding with about when we could expect a bed to open up for him. I just don't have a firm answer for the court yet.
I'm pulling up his case now. So has he, so there was a commitment order in November of 21, but then something happened in May of last year. Did you get him reevaluated, or did the competency, the restoration pod say things were better?
Judge, he's one of my clients where, yes, there was the evaluation, the order, he was restored, and then another evaluation had to be done. Currently, not competent.
Okay.
And so waiting for bed space at this time.
I'm just looking at the indictment. So it's been almost 2 years from indictment, not necessarily arrest. And the felony obstruction is that he grabbed the officer's hands. So he trespassed. He was in the Terminus building. He grabbed an officer's hands, and he's been in jail for a long time, and we're awaiting some mental health treatment. So I'm wondering if this is, well, it's not that we could take a plea. It's not in a position to do that. But if there are resources outside of government resources to which Mr. Harris can be connected. I don't have his criminal history in front of me. He may have stabbed 100 other people, and then I need to think about this a different way. I see someone who's not well, and when the emergency responder was a police officer as opposed to one of the mobile crisis units from Grady or PAD, it didn't go so well, but it wasn't in spit on anyone or stab anyone. And he's sitting in jail. Everyone's nodding. What do you see as a next step? Are we even in the queue for DBHDD from that order from 2 years ago, year and a half ago?
We're in the queue from a most recent, I think it was in October of 2022. I don't know if it's filed. I know Ms. Primovic had sent it off.
I don't, meaning, well, the order I did saying you need to go to DBHDD was in November of 21. And then something was filed under seal in May of last year, but I'm guessing that was he needs to be evaluated again. I haven't done anything else, so I may have dropped the ball if in my inbox from 4 months ago was hey, could you sign this?
I will double check. I know Ms. Primovic had sent something to court services, so I'll follow up with her. I did want to just let you know part of the issue, or not issue, but similar to how Mr. Torre didn't have any connections on the outside, we have the same situation with Mr. Harris. Although he does speak English, it's just there's no one. So
he's not from here, or if he is, everyone's gone.
Yes.
Okay. So he would be connecting to publicly available resources, not a family member, et cetera. Okay. Mr. Jordan, your thoughts about Mr. Harris's situation?
Your Honor, I'd be willing to work with, of course, with Ms. Wood and also Ms. Patterson. Some kind of solution that we can reach short of a plea in this situation, or at least to get him to a center that could help him. I understand that he's been in for almost a year or almost 2 years at this point.
Right. It will be 2 years in 10 days.
Absolutely, Your Honor. So I'm more than willing to work with them to see if we can get, maybe not so similar to Mr. Torres, but something that can get him in a.
Right. The tricky part for your office, and I say tricky only because you always have public safety as a concern, is that this wouldn't be a plea. Mr. Harris couldn't navigate a plea. Mr. Torre was right on the edge, but I felt comfortable that he understood what was going on, and he then went to a place of support. We all got that amazing picture of him holding the key. Mr. Harris, it may be that Ms. Patterson can line up resources like that. It may even be a little easier because there's no language barrier. And frankly, these allegations are a little less severe than Mr. Torres, where I think there was a blade involved. But the difference would be it wouldn't be a plea. And so I don't know if it would be everyone agrees that there's a bond with a check-in in 3 months, and then ultimately it's an NPGJ. I'm not sure. I would put it on judicial hold while he's out, and we'd have periodic checkups. But that's where there need to be creativity on your office's side. Again, looking one level deeper, what's the additional criminal history for Mr. Harris? I suspect if there is any, it's going to be situations like this where we don't call it vagrancy anymore, but he's where he's not supposed to be. It's criminal trespass. It's erratic behavior. If it's something more and there's someone who got a crowbar stuck in his head because of Mr. Harris, then we need to think about it the way we were alluding elliptically to Mr. Lowe, where in fact, there's not one, but there are 2 people who are dead at his hands.
And I have reviewed his criminal history. This is his first arrest here in Georgia. He has 2 cycles out of Chicago, one for criminal trespass, as to be expected. And the second, I would like to do a little bit more research into it. It says aggravated assault, but it's also a misdemeanor. So,
okay. But the fact that he has only 3 arrests nationwide is says that either he's had some source of support in some way, or that if on medication, things work more smoothly. Here's my request. If in fact Mr. Harris is in the queue to get to DBHDD, great. But this seems like, given that very, very minor criminal history and the nature of these charges, I'd like to put this on an inquiry calendar before you leave. So it would be late May, and see what Ms. Patterson can come up with. And it would be the defense's project, what Ms. Patterson can come up with. And then on the state side, if you'd work with a supervisor or whoever you need to work with, to see whether we could fashion something where everyone agree. Obviously, I'm signing the bond, but the DA's office consents to the bond, and I know there are some bail justice programs if the bond is low enough. I don't know that it can be a UJR. Maybe it can with these charges. Don't know, but that's navigable. I would want this to be something where the state is agreeing to it, because it would have a structure whereby some number of months out, we check again. This would be with your successor. And if everything is going smoothly, then we say, this is a case that's going away. If things are not going smoothly, this case remains open and there are new charges, and we realize that this wasn't an approach that works.
Yes, Your Honor. And I just received notification that I may depart earlier than June. It might be May 15th. The date is.
Boy. All right. Ms. Willingham, you ready to take over his docket too? You don't have much going on.
Judge, I would anticipate they will quickly get someone in.
I
don't know.
I would not expect you to step up.
But I will make sure that this is a case that's flagged, Your Honor. And even if I am out of this particular unit by the time that the case is back on the inquiry calendar, I'll make sure that I'm in here to handle it.
All right. I'm going to still put it down for a late May inquiry. I am praying to whatever powers are out there that Ms. Wood is still here in late May. And I forgot it was on mute when you broke the news over the lunch break. Yes, Mr. Jordan is leaving, Ms. Nelson. She's going to throw something at her computer now. It's good to be popular, though. We have had a few times when someone says I'm leaving, and then once the person's out of the room, we go. There's not any of you three. So we will put this down for an inquiry calendar in late May. We'll get an update from PD, Ray, programs, and update from the DA's office, Ray, bond, and future NPGJ. All right. So you can document that however you will, Mr. Jordan. It'd be great if your successor doesn't say, huh, when we are talking about Mr. Harris again.
Yes, sir.
Ms. Wood, is there anything I need to do? I guess this is what you'll talk to Ms. Primovic about, to advance things. I'm now reluctant to say, hey, DBHDD, come grab Mr. Harris. But if there were orders you thought I had signed, I'll tell you in the docket, the last thing I entered was in November of 21. Okay. And then I guess technically I did the May of 2022. That's under seal, but I'm assuming that was evaluate him again. And that's it. There's nothing in the docket.
I'm going to confirm with Ms. Patterson and Ms. Primovic, and if there is anything, I'll email Ms. Nelson.
Okay.
Thank you.
All right. Well, I'm cautiously optimistic about this. The Mr. Lowe situation, not so much. All right. But I think Mr. Lowe is here, and I want to say hi to Mr. Lowe real briefly so he can go. Mr. Lowe, are you there? I do see you. I'm going to wave, Mr. Lowe. See if I press that button, if it does anything. Hello, Mr. Lowe. There he is. Hello, Mr. Lowe. How are you doing today? Feeling quiet? Okay. Well, Mr. Lowe is free to go. Thank you for connecting him to the Zoom call. I spoke with his doctors, And if he doesn't have anything he wants to add, then he's free to go. Thank you. And I'll put that in the waiting room. Okay. That gets us to our co-defendants, Mr. Pitts and Ms. Diaz-Ortiz. And I see Ms. Diaz-Ortiz there. I'll add her to the spotlight. And Ms. Kaufman, her lawyer. There she is. Everyone's in cars. All right. Then we've got Mr. Kane. And is Mr. Pitts here today? Ms. Nelson, did we order up Mr. Pitts?
Yes, Judge, he was on the transport. Let me find out what's going on with him.
Okay. Do you all know if there's a Mr. Pitts in the house?
I think he's.
One bailiff's counselor asked to go back. And then
I think Pitts is back there.
Yeah, so now I'm remembering, Deputy Gordon told me we have two people here today, but they have to be kept separate, not from each other. But we have a Tidwell, who's our last one. She's here. She just can't come up at the same time because I think Judge Leffridge has a bunch of separatees as well. So he's back there now. Okay, well, it's good to know he's here. I'm going to talk with the lawyers and we'll figure out what we're doing.
But the female is back there. The male, one of the males down, so
It was Harris. I'm pretty sure Pitts is still back there.
Okay. Can someone check to see if Pitts is back there? Thanks. While you're doing that, so Mr. Kane and Ms. Kaufman, my recollection of how we left this, and it may have been the previous prosecutor for this unit, Mr. Whitenauer, is that Mr. Kane had asked not for another trial date, although I think you have one, but set this out for a little while because it's probably going to be a plea, but we need to talk. And I'm not putting words in anyone's mouth. This is my recollection of what it was going to be. The request was put it on an inquiry calendar, and Judge, we'll give you an update. But the likely outcome here is that this is not a trial, some non-trial resolution. You got your wish. It was put on an inquiry calendar, and we have brought everyone together again. So I don't know who wants to go first.
I will.
Okay, great. Don't be shy.
I won't. Those first two cases were a little triggering for me and Mr. Kane. As you remember our case before, Your Honor.
I do indeed. That's why we're careful with these.
Yeah, thank you. I just wanted to let the court know that the reason that we had put this on an inquiry calendar, my understanding at least, was because the state had been unable to find.
Yes, the alleged victim.
The alleged victim. And so that's at least one of the reasons. And then also to discuss offers.
Okay.
Yeah, so we'll go from there. That's fine.
Okay, great. So Ms. Willingham is gonna give me the deer in headlights look of, dang, I've got 4 cases for trial on Monday, and you want to know about this other one.
Well, Judge, I have at least attempted to make contact with the victim. I have not relayed an updated offer because I do know that the discussion was for adult diversion, and that is something that we have to have contact with the victim to do.
Adult diversion for both defendants or for Ms. Diaz?
No, as to Ms. Diaz.
Okay. Or Ms. Ortiz.
Or yes, Ms. Ortiz, I see it up there.
Yeah.
But because we have not been able to get in touch with her, that is not something I've been able to do. It looks like the last time we spoke with the victim was back on December 19th of 22. But we have not had contact with her this year. We were able to speak with a family member. I believe that was Monday. And they provided us with a Facebook account. So we have tried to reach out to her via Facebook. We have not yet heard back.
Got it. So here's what I see in looking at the docket. This case is on our May 8th trial calendar. Mr. Pitts has been in jail for 335 days. So by the time the trial rolls around, it'll be a year that he'll have been in custody. The state's got about a month to find the alleged victim if it's planning on going forward against either. Remembering the alleged role of Ms. Ortiz has a whole lot less to do with you finding the victim or not. It may for adult diversion, and I respect the entry requirements there. But the way I saw this playing out, if it was going to be a trial, is that it's State versus Pitts, not State versus Pitts and Ortiz.
Correct, Judge.
Okay. All right, Mr. Kane, you had dropped off. You're back now. Were you able to hear the things we talked about?
Yes, sir. I've heard it.
Okay.
Let me tell you my participation and my understanding. I spoke to John Whittingham or Willingham several, that's Jasmine Willingham.
Yeah, so it's Mr. Whitenauer. They're all W's, but yes, Whitenauer is who you spoke to a few times.
John Whitenauer several times. I also
hold on 1 second. I'm sorry. Is Pitts back there?
Yeah, I got it right.
Yeah, can we bring him? Can we bring him out? So your client, we're going to bring your client out, Mr. Kane, so he can see you and hear what's going on.
You can sit right here.
Hold on 1 sec. Here he goes. Mr. Pitts, I'm Judge McBurney. I think we've met before, but it's been a minute. We're talking about your case and Ms. Ortiz's case. Your lawyer's on the screen there. You can see Mr. Kane in the corner. You can see Ms. Ortiz, and you can see Ms. Ortiz's lawyer. The prosecutor is Ms. Willingham, who is seated at the table to your right. And I interrupted your lawyer when I saw that you might be here. I'm going to let Mr. Kane keep talking, and we're going to figure out what's next with your case, okay?
Yes, sir.
All right, back to you, Mr. Kane.
Okay, so I'm going to go to the short version. Could you set this on an inquiry prior to May 8th to see if the state spoke to their complaining witness? And if not, then I can get Raquan Pitt out of jail.
So that's sort of what this is. Let me give you a counter offer, but it's really a counter. Here's what's going to happen. It's going to stay on the May 8th calendar, but I will make an inquiry, copying all the lawyers on this case of Ms. Willingham as to any progress that's been made contacting the victim. If we get to the call of the calendar, which will be, I believe, before, I don't want to speak out of school here. Let me look.
Yes, Judge, the call of the calendar, I think it's, if I remember correctly, the trial calendar is the 15th. The call is actually the May 8th is when we're doing calendar call.
Yes, you're correct. So May 8th is when we call the calendar. We don't pick a jury till the 15th. So if by May 8th, the state has not contacted this individual and can't provide you with contact information, because I think part of it was you wanted to interact with this person as well, Mr. Kane. Then we can talk about release. And then frankly, you should say, great, let's go to trial on the 15th. And then the state's going to need to say, either we want a continuance, which likely would not be granted, or they'll need to come up with a way to prove the case without the alleged victim. And my understanding of the facts from the bond hearing is that that would be pretty hard to do. So I don't think we're going to do another calendar because it's just not that much time between now and the 8th. The 8th will serve as that inquiry calendar. That's when we call it. That's not the trial. So there's a week from that to the actual call of the calendar. Ms. Willingham can make a note, because I know sometimes because people focus on what's directly in front of them, what we'd hear on the 8th is, we can be ready. We'll figure out how to find the victim for this case on the 8th. If they don't have this person in pocket, then we will talk bond about Mr. Pitts's case. And a week after that, we'll talk final disposition of Mr. Pitts's case. Okay?
Judge, and if I may, I know that I heard Mr. Kane mention that he also wanted to speak with the victim.
Well, I said that because I'm pretty sure he had said that when this was a Whitenauer case. Mr. Kane said, look, I need to talk to this person, or at least I need an opportunity to. And that's when Mr. Whitenauer said, yeah, me too.
Well, and I guess what I was going to address with that was that per Mr. Whitenhour's notes, it looks like he and Mr. Kane spoke, and Mr. Kane has actually he's had contact with her more recently than our office. It looks
Okay.
like as recent as February. I don't know when this was last on a calendar, so I just wondered if that was after that calendar or.
No. Go ahead.
It was on a trial calendar in February, and it was from that date, February 22, and it was from that trial calendar when we had the call of the calendar that Mr. Kane suggested that we have this inquiry date, where the state was going to have here, it's almost 2 months to try to locate this person. So I guess my announcement is this May calendar would be the last calendar it would be on where the state could get a continuance. Well, I put that incorrectly.
Understood.
The state got its continuance. There would not be a continuance for the state because the state can't get their hands on the alleged victim from this May calendar.
Understood.
Okay.
So Judge,
Yes, sir.
Let me just clear up a couple things. I did speak to the victim. She did come, I don't want to call her a victim. The complaining witness, she came to my office. I contacted John Whitenhour. The complaining witness wrote Mr. Whitenhour a letter, and I sent her down to his office.
When was that? Dan, when?
I don't remember when, January, February, I don't know. I had several conversations with John saying, respectfully, you don't have a case here. And here's your complaining witness. Now, so I'm with the court on the May 8th calendar call, and we'll resolve it then. But just so the court knows that I've been proactively trying to get the state to work some understanding with this complaining witness to figure out what's up.
Right. I'm going to use her name, Ms. Glover. Ms. Glover is the name of the person that the state needs to find through Facebook or satellite imagery or whatever it's going to be. And Mr. Kane, you're exactly right. And I recall some of that now that you're refreshing my recollection that you said, look, I've been working with Mr. Whitenhour to try to connect the two. And if and when the state does reach Ms. Glover, they may have a new perspective on what the case is about. And so here we are on April 13th. May 8th is less than a month away. That gives a fixed window in which the state needs to find Ms. Glover. And if they do, maybe reevaluate the nature of the case, or maybe Ms. Glover says something different to them than she said to you, and that'll make for an interesting cross-examination.
That's right. And we still have Raquan Pitt sitting in jail for 335 days. So I look forward to hearing from Miss Willingham. And if I could get a phone number or somehow so I can reach out to her also. If you
I will put it in the chat.
Yeah, Ms. Willingham will put that in the chat on this Zoom, so you'll have a way to contact her.
Your Honor.
Ms. Kaufman, I'm assuming, other than allowing Ms. Ortiz to appear virtually for the call of the calendar, because if she's in Pennsylvania or somewhere far away.
Yes, Your Honor.
Okay, we're okay with the status quo for Ms. Ortiz. I mean, it's the same situation. The state's going to need to be ready to go forward, and if they're not, then that's their issue and not your client's issue. Ms. Ortiz, of course, will need to come to court if we go to trial. And so as she's looking at the week of May 15th, she should think about coming down to Georgia that week if there's not a resolution before then.
And so I just kind of want to let Your Honor know where we've, I don't know if she's sending it. Ms. Willingham, are you okay with the consent order? Here's my issue, Your Honor, is that back in December, we were talking about putting my client into diversion.
Mm-hmm.
Mr. Whitenhour said that he was actually going to submit it in February. During that period of time, I had asked them, and I did not file a motion with the court asking to modify the conditions of Ms. Ortiz's bond. However, she's been on an ankle monitor since July, has had no contact with Mr. Pitts, no contact with Ms. Glover, has a full-time job. She had some issues charging her the people down in Fulton County to let them know that purposefully not responding to them. And my goal was trying to, if she got into diversion, she wouldn't need the ankle monitor.
Right.
But we've been like months, 5 months for that. My concern is that her charge does not involve a victim.
Right. It's disposing of the gun or something like that is the allegation.
I don't understand why it can't be submitted to diversion.
Not my call. That you and Ms. Willingham can talk about that. I'm fine modifying the bond. I mean, we've gotten far enough along here and Ms. Ortiz shows up every time. I don't mind if someone wants to get me a proposed order modifying the bond that would remove the ankle monitor component. I don't mind doing that. I don't really want to do much else because we're a few weeks away from what's going to be closure in this case. Either the state shows up and says, we can't find Ms. Glover, or we did find her and we're reevaluating things. But if they find her, then Ms. Ortiz can get through this adult diversion, or Ms. Glover is here. She's got a different version of events and we'll have a trial. I suspect that will still resolve Ms. Ortiz's case. But I will, if you get me a proposed order, remove the ankle monitor requirement. Now, Ms. Ortiz can't just take it off and throw it away. She's going to need to figure out how to connect with A&A monitoring, and I don't know that they operate in Pennsylvania. So it may be that she's going to continue to wear it till she comes down here to sign up for adult diversion. Then she can get it removed. But Ms. Kaufman, you'd need to navigate that with A&A because they may say, wait, if you've discontinued the monitor, we need it back because we can put it on the next lucky winner.
And so I can include in the order that she may travel because she's been, she has to stay in Pennsylvania has been one of the conditions so that she can come back to Georgia for the purposes of dealing with her ankle monitor situation in court.
Correct. Yep.
Okay.
That'd be good. Mr. Kane, anything else on behalf of Mr. Pitts?
Nothing further, Your Honor.
Mr. Pitts, do you have any questions about what we've been talking about? Not the facts of your case, but just this process we've been discussing.
No, sir.
Okay. Ms. Willingham, anything else?
Nothing, Your Honor.
Did you get to Mr. Kane and Ms. Kaufman your contact information?
I got it to Mr. Kane, and Ms. Kaufman and I have been communicating via email. So
She knows how to find you.
Yes.
Okay, great. All right. Thank you all. Mr. Pitts, I will see you at the latest on May 8th when we call the trial calendar. Before then, I'm sure Mr. Kane will be talking with you because the state's going to need to redouble its efforts to try to find Ms. Glover, and that may change an offer, or who knows what they're going to do in connection with possibly resolving your case. All right.
Yes, sir.
All right. Thank you, everyone.
Good to see you.
Good day.
Off to the jail I go. That's right.
All right.
Judge, that concludes my business for this afternoon. May I please be excused?
Yes, ma'am. Thanks for being here.
Struggle to end.
Yep. So all we have left is Ms. Tidwell. I think, is she up or is she?
She's here, Judge.
She's here. Okay. Before we bring her out, this is on inquiry. She's got, it's funny. It says defendant will not be transported, but here she is. So she's got 3 cases now. Are they all with us?
Yes, Your Honor. All 3 cases are with us.
Okay.
I thought that she was still at Georgia Regional, and then surprise, she is here. I have reached out to Ms. Joyce Brown to see if I can get an update as to if she's in a program for restoration at ACDC, and I'm going to have Ms. Patterson speak with her today. I did speak with her before, and if you want to bring her to the door, that'd be fine, Judge, I think.
What are her charges on the other 2 cases?
She's got, let's see, there's an aggravated assault. Let's see, this one.
There's also a shoplifting case, Your Honor. I'm not sure which case is on.
Okay, but one is allegedly a crime of violence. The other is a property crime.
Yes, Your Honor, that's correct.
Okay.
And then there's another one that's a couple of obstruction counts.
There are 3 new cases?
There's 3 total.
Okay.
Yes.
Well, the one on the calendar is terroristic threats. And then there's one that's just 2 digits higher. That's 004. It doesn't matter which is which, but one of them is a shoplifting and one of them is an aggravated assault.
Yes.
But could be some obstruction tacked onto. Okay.
Yes.
Got it. Okay. But Ms. Tidwell, in terms of her status, it says loan out here, but she's back. And you're not sure if she's been restored.
I did not get notification. I thought she was still there. So I reached out to try to see what her status is. And of course, I'm gonna have Ms. Patterson speak with her.
Okay.
I'm not sure, Judge.
I just think maybe we had put her on here so we don't lose track of the situation. Why don't you all chat with her a little bit to maybe get a sense of where things are? And then we can figure out what is the next stop for Ms. Tidwell.
Yes, Judge.
All right. Before you do that, Mr. Hiles is here for our 1:30. Mr. Ratliff is not here. Mr. Ratliff is in the Oconee County Jail, where we have some overflow. And despite Ms. Nelson letting all the right people know that he needed to be brought here, he wasn't. And Ms. Wood, I worked with Ms. Wood a little bit to see, could we get you, Ms. Wood, on the phone with Mr. Ratliff? Would he want to appear virtually, et cetera? And that was all too rushed for it to allow Ms. Wood to be comfortable that they were having a meaningful lawyer-client interaction. So we need to reset this so that we can have Mr. Ratliff here in person, whether this is a full-blown evidentiary hearing or this is a non-negotiated stipulation to or admission of. The Oconee situation has further frustrated progress for Mr. Ratliff because I think Rockdale County was trying to get him this week to deal with what may be these new charges. And Oconee said, I can't let you because Mr. Ratliff has to be here. So they knew he had to be here and yet they didn't get him here. So no one's a winner with any of that.
If it's not, I was under the impression it was going to be a non-negotiated stipulation.
So that is what we were, and we talked about that. So what had happened was he appeared in February on a jail calendar, didn't want to do anything via Zoom. So I did speak to him via phone 2 days ago. Someone at the jail graciously hooked us up and he told me that he was fine coming here to do a non-negotiated. I was able to speak to him at like 12:56 today. He asked me if we could still do the non-negotiated via Zoom. I advised him we could ask for that. It is still my advice, knowing what the exposure is. It's just my advice to do it in person. It gives me more of a chance to speak to him in the back and go over what the state is asking for. But I did tell him that I would let the judge know that he was saying that he was fine doing it via Zoom. I know his mother is present. I've tried to explain to her that the state is looking to resentence him. So yes, it's a complicated situation.
Okay, let me check one thing here. So I have, one person has office hours until 2, so that would be 9 minutes. And then there's someone else, both Oconee people, that we could call to see if we could get them to get Mr. Ratliff onto a Zoom session. And I guess in theory, he could go in a breakout room. You could be on your phone. You could go in a breakout room and you all could talk. I'm open to that. I have time because I'm presiding. I'm around. I have something at 4. But I'm also, I'm not delaying anything intentionally. Things are obviously being delayed. I don't want to rush it either. It doesn't sound like you're saying anything has changed about it's a stipulation. And so it's basically a sentencing hearing. It's not that the state needs to produce law enforcement or other witnesses from this underlying conduct. It just would be a discussion about what's a reasonable outcome given a stipulation.
Correct, Judge.
Okay. How would you like to proceed?
When I spoke to him at 12:56, he asked if I could ask for Zoom. Again, it's his decision. So I think I've explained to him the pros and cons of appearing via Zoom.
Okay. Are you available for a little while? If I have Ms. Nelson contact one of these 2 folks at Oconee to see if we can get Mr. Ratliff connected via Zoom. Are you able to stick around?
Yeah, absolutely. Do you have time to grab a water bottle?
You do. You do. But come back.
Well.
All right. Ms. Nelson, I'm looking at the email you shared with me. Can you reach out to Captain Toe or Deputy Geth to see if they would be willing to get Ratliff in a Zoom space?
Yes, I will.
Thank you. All right. but that leaves us with Ms. Tidwell. I'm happy to say hi to her, but I don't know what the value, oh, you were gonna go talk with her. So why don't you guys talk with Ms. Tidwell while we're waiting on the Ratliff situation?
5 minutes, 10 minutes.
5. You don't need that big a water bottle.
I'll send an email if I can. Your Honor, I have a little bit of information on the victims for the aggravated assault and for the terroristic threats. It's the same victim, but I'll wait till Ms. Wood.
Oh, in Ms. Tidwell's situation. Okay, all right. Ma'am, are you here for Mr. Ratliff? Okay.
What I'll keep doing, Judge, if it's okay, I will just disable my camera. And then when it's on the record, so that I'm present. I didn't go anywhere.
No, I appreciate that. No, that's great. And it may be we end up with nothing on the record from this calendar or the next one, this one with Ratliff. We'll just see what we learned from Oconee.
Okay.
Thanks.
I've never seen these before, but I definitely want to steal one of these. I love gummies, but I've never seen this before. So I'm
Well,
definitely
it's gummy what?
Fruit Loops.
Okay, so that's thank Ms. Niles. I was the chocolate guy earlier this week and you guys quickly pilfered that. Ms. Niles had a bunch of extra Easter candy and so that's coming from her. I've never seen gummy Fruit Loops either.
Thank you, Ms. Niles. Hopefully my wife is not watching.
All right. We're not getting an answer from Oconee. Let's have them come out. They can talk longer, but we can shut things. We just have folks on this call who don't need to be sticking around if we're not going forward with stuff. Yes, please.
Yes.
Hey, two things. Ms. Nelson tried both phone numbers in Oconee and got no answer. So we're gonna have to reschedule that, and we'll just get Mr. Ratliff here.
Yes.
So everyone will be able to, well, not everyone, you'll be able to speak with him and whatnot. So my executive decision, and my apologies to family. I mean, I didn't do anything, but still, it's frustrating. You came all the way down here from wherever, brought someone little with you, and no Mr. Ratliff. All right. Well, I bet he would like to see his son. So your grandson. So we will need to see Mr. Ratliff someday soon. What about Ms. Tidwell?
Ms. Patterson is working her magic. I think this one, Julian, you can, I think if we could have another, I don't know if it needs to be inquiry. I don't have an update from the team with Georgia Regional as to why she was brought back. I think Ms.
So
Patterson.
it seems like it should be inquiry. We can turn it into something else, but we'll need to get that. I mean, there ought to be some kind of paperwork from Georgia Regional saying everything was good, or she's beyond our reach, or whatever the situation is. Because it.
Yes, I would ask for another inquiry calendar.
Okay. We'll do that. And go from there. Is this Mr. Hiles after his 5-minute break? There he is. We struck out with Oconee. No one answered either number. So we are going to reset this and make real clear on the order. No, we mean bring him here when we say bring him here. And see if we can get Mr. Ratliff, and then we'll do whatever the hearing is going to be. You and Ms. Wood should keep talking. It may still be a stipulation and thus a sentencing hearing, but you're not going to be blindsided. If suddenly Mr. Ratliff switches and says, no, I want an evidentiary hearing, I'll explain, okay, that's another day, because going into this, the state thought that the focus was going to be what ought to happen because of these things, as opposed to prove these things up.
And one of the reasons I got Ms. Ratliff approached me in the hall, talked with her. I'll tell you this, if instead of going completely non-negotiated, I would only ask to revoke and resentence. I would ask for 15-3. If he's willing, as the special conditions, 1, he'd have the statutory gang conditions. 2, he'd have to enroll in and complete.
So I'm just going to, you guys can do whatever you want. I want to let folks on the phone go, and we'll move on. So you guys can
I'll talk to her. I didn't realize there was more on there.
hash that on. No, I just, this was it. So Ms. Sanders, we are done. I don't know that you had to take much down today, but we needed you just in case. We had all these miracle pleas. Ms. Jackson and Ms. Tucson, there was a chance that we would have had a plea with, well, not a plea, a revocation with Mr. Ratliff. And I thought Mr. Pitts was potentially a plea. That's how it had been structured before. So I appreciate you all being here. You are free to go. Let me just look. Tomorrow is, what is that noise?
Thank you, Judge.
Okay. Friday, we've got a motion for new trial and a motion hearing. We do not need pretrial or Ms. Tucson tomorrow. It's all motions hearing stuff. So you guys have a great few days.
Thank you.
You're welcome. Oh, look at that
I'm
bridge.
popping up, but I will get it to you. Not a problem.
All right. So Mr. Lowe, you're back. We are ending the call. We finished everything we needed to do. Okay. I hope you're doing well, and I hope to see you soon.